wish I could believe that.
June 17, 2011. U.S. law allows testing of chemicals and biological agents on civilian population. Quote, Public Law 105, 85, November 18, 1997. Use of human subjects for testing of chemical or biological agents. Section 1078 Restrictions on the use of human subjects for testing of chemical or biological agents. A. Prohibited activities. The Secretary of Defense may not conduct directly or by contract. 1. Any test or experiment involving the use of a chemical agent or biological agent on the civilian population. Or 2. Any other testing of a chemical agent or biological agent on human subjects. B. Exceptions. Subject to subsection C, D, and E, the prohibition in subsection A does not apply to a test or experiment carried out for any of the following purposes. 1. Any peaceful purpose that is related to a medical, therapeutic, pharmaceutical, agricultural, industrial, or research activity. 2. Any purpose that is directly related to protection against toxic chemicals or biological weapons and agents. 3. Any law enforcement purpose, including any purpose related to riot control. So Section A prohibits these cruel and inhumane chemical and biological tests on humans. Then Section B says that the prohibitions in Section A do not apply to tests carried out for virtually any purpose. So Section B completely negates the prohibitions of Section A. In other words, the U.S. government can test chemicals and biological agents on humans for nearly any purpose they desire. The following should also be noted. The term biological agent as stated above in A. 1 is defined in E as follows. Quote, E. Biological agent defined in this section. The term biological agent means any microorganism including bacteria, viruses, fungi, rickettsia, or protozoa, pathogen, or infectious substance, and any naturally occurring, bioengineered, or synthesized component of any such microorganism, pathogen, or infectious substance, whatever its origin or method of production, that is capable of causing 1. Death, disease, or other biological malfunction in a human, an animal, a plant, or another living organism. 2. Deterioration of food, water, equipment, supplies, or materials of any kind. Or 3. Deleterious alteration of the environment. In other words, the U.S. government can test chemicals and biological agents on humans that cause death, biological malfunction, and deleterious alteration of the environment. The term deleterious alteration of the environment brings chemtrails to mind. Read about actual human chemical testing programs currently in operation. Herbalord.com web link. Read the full text of this law here. Page 287 contains the above excerpt. Public Law 105-85. Informed consent. Some argue that none of this activity can be conducted without informed consent, as stated in Section C, which reads, quote, C. Informed consent required. The Secretary of Defense may conduct a test or experiment described in subsection B, only if informed consent to the testing was obtained from each human subject in advance of the testing on that subject. Although Section C seems to provide some protection for us in that it requires us to be notified in advance if this testing is to take place, in reality, it does not provide any protection at all. Why not? Because you've already been informed in advance and you've already given your consent. Because this law is publicly available for everyone to read, you have been informed. Because you have not contested it, that's what the courts are for. You have provided your consent. This law is part of a contract between you and the government. When the terms of a contract are known and uncontested, it's called acquiescence. Acquiescence essentially means that both parties are in agreement. Acquiesce. Submit or comply silently or without protest. So, when this law was published, you were informed. Because you have not challenged it in court, you have consented. By your own inaction, you have said, sure, go ahead and poison me, even if it causes death. I have no problem with it. Because this contract meets the judicial requirements of remedy and recourse, it is legally binding. Judges like to say, ignorance of the law is no excuse. They say this because you are expected to know all of the law because it is publicly available for you to read despite the fact that this is humanly impossible. So, in reality, Section C is legally useless. It does not provide any additional protection, it only seems to. Section C's only purpose for being included in this law is deception, nothing more. Deception. Section C of this law is very deceptive because most people don't understand the concepts of acquiescence in contract law. Therefore, people mistakenly conclude that this testing will never happen to them unless they are informed about it. The powers that be play upon public ignorance by inducing people into having a false sense of security. As a result, the public believes this activity could not be occurring because they believe that they would have personally heard about it. This false belief then provides insurance that this law will never be contested in court, and as long as this law remains uncontested, chemtrail spraying will continue unhindered. The final result is that this craftily written law has done its job. It has enabled chemtrail spraying to continue without being contested in court. Additionally, this law continually provides legal protection for those doing the spraying. After all, by your inaction you have given them your permission. When you consider the incredibly dark nature of this deception and when you consider the fact that this law gives your public servants the self-appointed power to kill you, you should then consider what kind of people are running your country, or the world for that matter. All links in the show more of this video. Hugs, Lena, Ohio on YouTube.